appellee Laura Cavaretta is attorney Samantha Lednicki.
Okay, thank you very much. Good morning again, everybody. Mr. Isham, can you hear me, sir?
Yes, Your Honor.
All right, and I can hear you just fine. You understand you have 5 minutes, and we'll try to give you an alert when you have about a minute remaining. So please go ahead.
All right, my name is Zachary Isham, and this appeal turns on factual findings directly contradicted by certified medical records that the trial court refused to analyze, despite stating that it would consider certified evidence that showed otherwise. This failure, combined with skipped statutory analysis and clearly erroneous factual findings, requires reversal under Vermont Supreme Court precedent. Number one, the certified medical records directly contradict the trial court findings. The trial court found that the mother was completely appropriate and responsive. Certified medical records show conflicting histories from the mother. In July of 2024, she reported no behavioral concerns. In September of 2024, she reported recent concerns. In October of 2024, she reported long-standing concerns. Under Cabot v. Cabot, 166 Vermont 485, findings contradicted by documentary evidence are clearly erroneous and must be reversed. The trial court relied solely on Exhibit L and refused to consider the complete certified medical records submitted afterward. Number two, the court's findings that Aaron had services in Vermont is clearly erroneous. Judge found Aaron has services in Vermont. Certified records show no counseling in place at the time of trial. Dartmouth recommended referral to Northeast Kingdom Health and Human Services because services were not in place. Appellee's counsel had also admitted counseling had stopped. Under Wells v. Wells 150 Vermont 1, findings must be based on full factual picture. Incorrect factual premises invalidate the discretionary determination. Number three, the certified records show multiple unmet medical needs the court never analyzed. Certified records document delayed autism screening, no behavioral assessment despite years of symptoms, missed referrals for needed services, providers relying on school behavior reports only because me as the father supplied them. Under or in REAM 2015 Vermont 109, failure to address a child's medical needs supports modification of parental rights. In REMB 162 Vermont 229, delay in securing necessary evaluations is evidence of unmet developmental needs, a key best interest factor. These issues were never evaluated because the judge refused to consider the certified evidence. Number four, the court failed to apply the required 665B best interest factors. The court made best interest conclusions without analyzing any statutory factors. This violates Harris v. Harris, 149 Vermont 410. The trial courts must apply statutory criteria. Nickerson v. Nickerson, 158 Vermont 85. Failure to assess credible evidence related to statutory factors is reversible error. Gilman v. Gilman, 2023 Vermont 13. Ignoring evidence relating to developmental needs requires remand. Certified medical records directly implicate multiple 665B factors, but none were evaluated. The trial court refused to review certified evidence despite inviting it. Judge Schoonover stated she would consider certified records if they show otherwise, and they did. Yet the court denied post-judgment motions without findings. Under Goshi v. Mori, 539A 2D 543, courts must hold a hearing or issue findings when new evidence could affect the outcome. In BR 2021 Vermont 81, family courts must assess newly submitted evidence when it concerns ongoing child welfare. The trial court's refusal to analyze certified evidence was a procedural error requiring reversal. And I'd like to save the rest of my time for rebuttal, if possible.
Okay, thank you very much. We'll turn to counsel for the appellee. Please introduce yourself, identify your client, and then proceed.
Thank you, and may it please the court, I am attorney Samantha Lednicki. My client, Laura Cavaretta, formerly Isham, is mother in this case. The father's main argument on appeal is that there exist these medical records that somehow demonstrate mother failed to meet the children's medical or developmental needs. But that's not what these medical records prove. The court did consider a 44-page document from Dartmouth Hitchcock regarding one of the children and considered that as evidence that there was concerns regarding the child's behavioral challenges. These were challenges that were undisputed by both mother and father on the record in both of their testimony. But just because a child has challenges does not prove that one party was at fault for those challenges. What was proven is through mother's own credible testimony that mother did adequately and diligently address the child's developmental and medical needs. If the court looks no further than transcript pages 85 to 87, that is where the credible evidence from mother comes, outlining exactly how she met the children's needs. And this court must uphold factual findings if there is any credible evidence in the record to support those findings. And the credibility determinations are left squarely to the trial court. So father in this case may be unhappy with how the court dealt with that evidence, but the court credited mother in her testimony that she was adequately and diligently meeting the children's needs, specifically the one child in which there was evidence of some significant behavioral challenges. The court needed to look no further than making that first threshold jurisdictional finding that evidence that a child had behavioral needs and that mother was adequately meeting those needs to resolve this case. As we all know, in 15 VSA 668, a modification can only be granted when two things are found. First is that there was a real, substantial, and unanticipated change of circumstance. And in this case, the court found that such behavioral challenges did not warrant that high and heavy burden to modify either parental rights and responsibilities as to that one child or increasing parent-child contact to father. Father next makes a challenge. So I guess in terms of father's argument that the court did not go into the best interest analysis in this case, the court was not required to do so. When the court finds that the moving party has not met their burden, that there's been a change of circumstance, the court does not need to go into the analysis of best interest. However, in this case, the judge did go into that analysis. On the record, in her oral findings, the judge specifically says, with respect to the change to parental rights and responsibilities, she says it would never be in a child's best interest to drastically relocate them away from their primary caregiver, the custodial parent who has been both children's primary caregiver since they were born, and move them out of state, out of their community. The court is also not required under Harris v. Harris to go through each enumerated of the 9 best interest factors. It's just required to consider each of those factors. And it was clear from the oral findings and the written findings that the court did consider each and every best interest factor in which there was evidence submitted. And this squarely aligns with Harris v. Harris. Next, father challenges.
You have 1 minute, counsel. 1 minute.
Thank you. Next, father does challenge the denials of the 2 post-judgment motions. These 2 post-judgment motions really hinge on the fact that the only admissible medical record that was able to be admitted, because it was the only record that was properly certified as a business record under Vermont Rules of Evidence 803, that he should have had an opportunity to submit other medical records. And specifically, his Rule 60b2 motion hinges on the fact that those medical records that he sought to introduce in post-judgment filings were newly discovered evidence. But what he fails to cite in that rule is that it's not just newly discovered evidence, which clearly all of this evidence was available. It's not new. It was available at trial. But he also claims that, or he fails to read the rest of that statute, which is that the due diligence, it must have been discovered under with due diligence, and he fails to quote that.
Okay.
Thank you. Sorry.
Thank you. Your time has expired. How much time does the appellant have, please?
Appellant has 1 minute and 3 seconds remaining.
Did you hear that, Mr. Isham?
Yes, Your Honor.
All right, please proceed.
So Attorney Lednicki stated that the records that I submitted in my post judgments were newly found. However, those certified medical records were certified prior to the original trial and were just not submitted by my previous counsel, who had them in her possession months before. Additionally, the Exhibit L that Attorney Lednicki is referring to, the 44-page document, is just one appointment. It does not cover the 4 years of medical records that I have that show a direct contradiction to the court's findings. So to base everything solely off of the one record is clearly erroneous when there are 4 years worth of records that show otherwise. And the court, even Judge Schoonover said herself that she would consider certified evidence, and when that evidence was submitted, she did not consider it, and there were no actual findings, specific findings to that. I see my time is up.
Okay, yes, your time has expired. Thank you very much. Please call a conclusion of the hearing.
The next hearing for the court